I am lead administrative law judge Sarah Hosey. With me today are my panel members, Judge Suzanne Brown and Judge Josep Hokopchikan. Thank you for joining us today. Before we go on the record, I will go over a couple of announcements and recap where we are in the appeal following our pre-hearing conference. So the Office of Tax Appeals will be conducting today's hearing electronically with the agreement of the parties and participants. This is the same platform we use for the pre-hearing conference, except today we have our judges with us. And also present is our stenographer, Ms. Alonso, who will be reporting this hearing verbatim. To ensure we have an accurate record, we ask that everyone speak one at a time and not speak over each other. Also, speak clearly and loudly. When needed, Ms. Alonso will stop the hearing process and ask for clarification. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. Today's proceedings will also be live streamed. The transcript and video recording are part of the public record and will be posted on our website under hearings. During today's hearing, OTA asks that you please do not use the chat feature in WebEx. Please mute your microphone if you're not speaking to avoid feedback and background noise. And if there are any questions during the process, including any questions regarding technology, the questions should be directed to me. And if you have problems or become disconnected, just please wait and we'll contact you.
How do you mute your microphone?
Oh, at the bottom of the panel, there should be a, it looks like a little microphone, like an oval. And it may say mute next to it, may not. I think if you press that, it will mute. See it, Ms. Goldfarb?
No, I see connect audio, stop video, share, the hand, the face, dots.
You know, I can have our team control the mute function for you. Would that be all right?
Sure.
Okay. Thank you. Ms. Vaughn's on that for me. So right now we're off the record, so that's okay. If you have any other questions, just let me know. I'm going to do a bit of review, like I said, and we're going to go over what we discussed at the pre-hearing conference. We're going to go over the additional exhibits that were submitted after the pre-hearing conference, and I'll answer any more questions you have. Then we'll go on the record, and our stenographer will then transcribe. So any questions before I continue? Seeing none. I'm the lead judge for the purpose of conducting this hearing, but all three judges on the panel are co-equal decision makers, and we've read the briefs and examined the exhibits before this hearing today. The issue that we are discussing today is whether the claim for refund for the 2016 tax year is barred by the statute of limitations. Is that accurate, Mrs. Goldfarb?
Yes, but also not necessarily the refund, but the amount that was taken out of the account. I can't hear anymore.
Judge Hosey, we are unable to hear you.
No, I'm not sure. It doesn't look like I'm on mute.
We can hear you now.
Oh, you can hear me? Okay, I'm not sure what happened. Maybe a little glitch in the system. Okay, so back to the issue. Ms. Dixon, is that accurate?
Judge Hosey, the issue, as you stated, it is accurate.
Okay, thank you. All right, I want to go over the documents that were submitted. We had appellants 1 and 2 and respondents A through G that were admitted into the record of the pre-hearing conference, but we had new exhibits submitted, so I want to go over those right now. Ms. Goldfarb, you submitted 6 additional documents. I've labeled them 3 through 8 to continue from 1 and 2. Exhibit 3 is the 2012 to 2016 Excel summary SNP. And then Exhibit 4, we have the 2013 tax return transcript. Exhibit 5, we have previous year's adjusted income and tax payments. Exhibit 6 was the 2013 tax summary and the 2014 1040. Exhibit 7 was the 2015 tax summary and 1040. And Exhibit 8 was the 2012 tax summary and 1040. Is that right, Mrs. Goldfarb?
Yes.
Okay. Ms. Dixon, did you receive those documents?
Yes.
Do you have any objections to those?
No.
All right, we'll enter those onto the record shortly. And then from the Franchise Tax Board, I have the Exhibit H 2014 Demand and Tax Return. Ms. Goldfarb, did you receive that document?
H, I should. Yes.
Okay, do you have any objections to that document?
No.
Okay, I'll enter that into the record shortly too as Exhibit H. Okay, so Mrs. Goldfarb, we'll start with your 15-minute testimony and arguments under oath, so I'll swear you in. Then we'll have some time for questions. Ms. Dixon, I believe you will have then 10 minutes for your arguments. We'll have additional time for questions. And then Mrs. Goldfarb, you will have 5 minutes for a final statement. Do I have any questions before we go on the record? Okay, hearing none, is my panel ready? All right, we are now on the record. This is the appeal of C. Goldfarb, case number 210-98546. Today is January 27th, 2023, and it's approximately 2 p.m. This hearing is being held virtually via WebEx with the consent of the parties. I am lead administrative law judge Sarah Hosey, and with me today are Judge Suzanne Brown and Judge Josep Hakobchikian. I want to remind today's participants that the Office of Tax Appeals is an independent appeals body staffed by tax expert and is independent of the state tax agencies. Our decision will be based on the arguments and evidence provided by the parties on this appeal in conjunction with the appropriate application of the law. We have read the briefs and examined the submitted exhibits and are looking forward to the presentations today. Can I have the parties please state your names for the record? Starting with Ms. Goldfarb, please.
Karina Goldfarb.
For the Franchise Tax Board.
Camille Dixon, Tax Counsel.
Topher Tuttle with Franchise Tax Board.
The issue on appeal today is whether the claim for refund for the 2016 tax year is barred by the statute of limitations, and the amounts are also in dispute. As for the exhibits, we have marked exhibits 1 and 2 for appellant and A through G for respondent at the pre-hearing conference held on November 30th, 2022. No objections were raised by either party, and exhibits 1 and 2 and A and through G were admitted into the record. We have also marked exhibits 3 through 8 for appellant and exhibit H for respondent. Ms. Goldfarb, were there any objections to those exhibits?
No.
Ms. Dixon, were there any objections to those exhibits?
No.
Having no objections, exhibits 3 through 8 and exhibit H are now admitted as evidence into the record. All right, Ms. Goldfarb, we're going to swear you in. Can you please raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, you have 15 minutes for your testimony and arguments. Please begin.
So I agree that I was late filing taxes for 2016, and I agree that I should have a penalty for being late. At the time I started receiving all these notices, I was really overwhelmed with the language, and it's something that I'm not used to. At some point, I requested my accountant, my former accountant, Steve Temple, to help me with these notices to take care of it. he answered back that he was busy taking care of other customers and couldn't take care of it for me. So until I got another accountant firm to help me out, it was too late. It was past the statute of limitation time, and the money was already pulled out of my account. So this new accountant helped me appeal, and that's why we're here. But initially, the problem was that my former accountant didn't help me, and I didn't know how to manage. There were difficult times for my business. I had to let go of my bookkeeper. I had to take care of everything on my own for the business, and my priority was to keep going and keep the business running and having new collections and everything else but the taxes. And my major mistake was assuming that, knowingly, that eventually I will take care of the taxes. I thought that even if I don't do it timely, I will be able to recover the money that was levied from the account. And that's my mistake, because I was ignorant. I didn't know any better. I just assumed wrongly that that's the way it will be. And now I hurting. I have less money on my account because the money was levied, and I didn't understand how this this amount came up to be. Somebody explained to me the other day on the pre-hearing, and I understand there's several forms of coming up to this amount, but I feel that it's unfair that nobody looked exactly into my situation and my tax returns from previous years that show that I wasn't paying that much money for taxes. So I know I owe money for the penalties, but I took care of the 2016 taxes eventually and didn't have that type of income to pay this much money that it was calculated. And that's my main request, that it will calculate this amount based on the reality of my business and not compared to other type businesses that I'm not even sure what type of businesses those are that were compared to mine. It looks to me like they will not apply all the expenses that it takes to manage this business. So I request an explanation of what type of business my business was compared to come up with this amount that I feel is unfair. This is what I'm requesting. I'm not saying that the statute of limitation time didn't pass. I'm not saying that I shouldn't be paying a penalty. I'm saying that I feel is not the actual reality of my business, the amount that was charged at the time. And that's what I'm requesting to be reviewed, basically. It's just that. I think I was pretty clear. I mean, my fault for being ignorant about the way things are with the IRS and the taxes and how things are. It's the first time I go through this. And also the lack of knowledge of legal terminology that didn't help me to take care of this timely. So that's basically. So I did submit this Excel sheet proving that, and there is all the documentation attached, that the previous years, the adjusted gross income were under $10,000 from 2012 to 2016, 2016 included, and not what was calculated by the Franchise Board of Equalization. And I conclude my explanation.
Thank you, Mrs. Goldfarb. Appreciate that. Let me see if questions?
No questions.
Dixon, let me check with my panel members as well. Judge Brown, do you have any questions?
I do not, no.
Judge Hakochian, you have any questions?
No questions here, thank you.
We can hear you.
Can you hear me?
No.
We can
Okay.
hear you now, but I think there's issues when you come back on that we're not able to hear you.
Okay, I will just yell into the microphone here. Let's go ahead. Thank you, Mrs. Goldfarb. We will have 5 minutes for another statement after the Franchise Tax Board has their presentation. So, Ms. Dixon, are you ready to begin your presentation?
Yes.
Please begin when ready. Thank you.
Good afternoon. My name is Camille Dixon. I am tax counsel with the Franchise Tax Board and will be representing the Franchise Tax Board. Along with me is my co-counsel Topher Tuttle, Tax Counsel 3 with the Franchise Tax Board. The evidence shows that the appellant has failed to establish that a timely claim for refund was filed for the 2016 tax year before the statute of limitations expired. Under the applicable section of the Revenue and Taxation Code, the general statute of limitations provides that the last day to file a claim for refund is the later of 4 years from the date the return was filed, if filed within the extended due date, which does not apply here, 4 years from the due date of the return without regard to extensions, or 1 year from the date of overpayment. For the 2016 tax year, both the 4-year and 1-year statute of limitations expired before appellant filed her return. She late filed her return on August 4th, 2021, well after the 4-year statute of limitations, and the last payment FTB received was on April 19th, 2019. Therefore, the 1-year statute of limitations is also unavailable to allow a refund for the appellant for the 2016 tax year. Appellant contends she gave the tax information to her accountant. The accountant late filed the return, and she should still be eligible for the refund. And while FTB is absolutely sympathetic to appellant's unfortunate situation, such hardships do not change her responsibility to timely file a return and will not extend the statute of limitations. Further, there is no reasonable cause or equitable basis for suspending the statute of limitations. The Office of Tax Appeals, in its precedential opinion, Appeal of Benemi Partners, found that the language of the statute of limitations is explicit and must be strictly construed. And the United States Supreme Court in United States versus Dahm explained that this is true even when it is later shown that the tax is not owed in the first place. Unfortunately, FTB is prevented by law from granting appellant's claim for refund. FTB therefore respectfully requests that the Office of Tax Appeals sustains the Franchise Tax Board's claim for refund denial for the 2016 tax year. Thank you, and I am happy to answer any questions.
Thank you, Ms. Dixon. Let me check with my panel to see if there are any questions. Judge Brown?
No questions at this time, thank you.
Judge Hakochian?
No questions here, thank you.
Thank you. I have no questions right now either, but Ms. Goldfarb, you do have 5 minutes for any final statements you'd like to make before we close the record for the case. Do you have any other comments you'd like to make?
No, just a matter of timing. I mean, I requested help from the accountant was March 2019. Then the statute of limitation ended up by April 15th, 2021. And I did file in August 2021, which was a few months after the statute of limitation had ended. And it's a shame for a few months that I didn't get my act together and taking care of, finding a new person who did take care of my taxes and help me through this, that I've been punished that way, because that money makes a big difference. I'm struggling with the business, and most likely the business is not going to stay open. So I just ask for consideration. That's all.
Ms. Goldfarb, we really appreciate you I'm going to check with my panel. Can you hear me?
Now we can.
I'm sorry. Thank you for coming today. We really appreciate your time in this matter. I'm going to check with my panel one last time just to make sure we don't have any further questions. Judge Brown, do you have any other
No,
questions?
No, I do not. Thank you.
Judge Hakobchikian?
I have no questions either. Thank you.
Okay, thank you. So evidence has been submitted into the record, and we have the arguments in your briefs as well as the oral arguments and testimony presented today. We now have a complete record from which to base our decision, and we're ready to submit the case. The record is now closed. This concludes the hearing for this appeal. The party should expect our written opinion no later than 100 days from today. With that, we are now off the record, and the hearing is adjourned. Thank you, everyone.
Thank you.